Hello there, I'm making this video from a foreclosed house no one but me lives in. Did I live here before? No, but I saw no one had been living in it for a while, so I decided to just sort of move in the meantime. Here's my room. Pretty sweet, right? Living for free rules. The landlord is outside with the cops, but guess what? They can't make me leave because of squatters' rights. Okay, not really to me living in a foreclosed house, but to the whole situation that can hypothetically happen. Squatting. Squatting is a versatile word. What do you think of when I say the word squatter? Is it Ronnie Coleman? No? Maybe it's a Slavic guy in a tracksuit. Yes? Okay, well, that's not what I'm talking about today. The definition I'm talking about is this: squatter. Someone who unlawfully occupies an uninhabited building or unused land. Now, I'm no landlord sympathizer, but I'm also not a fan of freeloading, and squatting might be one of the most insane forms of freeloading out there. But what's the problem? Just kick them out, right? Wrong. Though even in the definition of squatter it specifies that it's an unlawful, aka illegal act, removing a squatter isn't that simple because of a set of very strange laws called squatters' rights. Now, if you're a terminally online individual, you may have seen some videos of property owners doing some very strange things to get squatters out of their property, in many cases while the cops sit unable to do anything. I have seen lots of these videos, and they're always very entertaining, but they also kind of baffled me as to why it's so difficult to get squatters out of a piece of property and why they would have any sorts of rights to begin with. But like most things that don't make any sense, once we look at the contextual history around our question, our answer becomes a lot more clear. In fact, the act of squatting has a deep history. It goes all the way back to ancient Roman times, at least in the form of written law. Uso capio was their word for squatting, sorta. Basically, if someone lived on someone else's unused land long enough without dispute from the true owner, the squatter could eventually take legal ownership of the land. And this whole process was called uso capio. And this is important beyond it being the first historical version of squatting. You see, medieval Europe, in particular England, would take great inspiration from this concept. In smaller continents like Whittle Baby Europe, land is a lot more precious. It's not like the United States where we have entire states of nothing. I'm looking at you, Kansas. So when land isn't being used properly, it's more of a significant issue. Keep in mind, this was far before global trade routes and in a time where countries actually needed local farmers in order to keep the population from starving to death. So when land was just not being used, other people would simply use it. Now, the other half of this early squatting problem was that record keeping in medieval England was shite, as their local dialect would describe. And so in many cases, land disputes would devolve into this he said, she said quarrel of angry peasants, and the authorities would ultimately just side with whoever was being more productive with the land. Now, I'd like to note something here: the phrasing and use of the word productive. The idea of productive use of land was what validated the early forms of squatting, and in much of the cultural context of squatting, it continued to make sense. In fact, this concept of someone using unused yet owned land in a productive manner was so effective in the courts that it just became a part of English common law. But there was a small problem. How long did the squatter have to live on the land in order for it to become theirs? The whole idea of productive land use certainly made sense on paper, but something that was not addressed for literally hundreds of years was the question of duration. People could claim another's land after just like a month of living on it. What if the person was out of town? You see what I mean? That could be a problem. Well, the English, after a few generations worth of squatters, also saw how this could be an issue. So in the 1623 Statute of Limitations Act, it was finally addressed. In the 16th chapter, the act would lay out laws in regard to land disputes, who could sue who over what. When it came to land ownership, the state wanted to establish certainty of ownership and productive use of the land. So the time frame they came up with was 20 years. So, for example, let's say a landowner neglected his land for 20 years while his neighbor farmed it. Well, the landowner wouldn't necessarily own his land anymore, since the squatting neighbor had lived on it continuously for 20 years undisputed from the original owner and was being more productive with it. Now, technically, it belonged to the squatter. And this practice of taking land against the owner's interest would go on to establish the law of adverse possession. How is this important in regards to the squatter that lives in your uncle's shed in Idaho? Can you guess? Can you guess why English common law is important to U.S. history? I'm sure you can. There were these things before the United States was a country called the colonies and the pilgrims, and while the pilgrims and the colonists came largely from England. Sure, a lot of the colonists made their own laws, partially based off of their religious beliefs, but most of the colonies, from my understanding, used a lot of basic English common law. Now, I certainly had the question of why would adverse possession of land be an issue in a place that was literally just wide open land? Couldn't everyone just get their hands on land? Yes and no. People could just post up and say they lived there now, yes, but was the land good? Was it fertile? Were there indigenous tribes there trying to kill you? But most importantly to all of this, there weren't many deeds to land or official ownership. It was just a lot of, I live here now. So as the colonies expanded further and further out, these disputes came all the more common amongst the new settlers. And the age-old issue of who owned it would rear its ugly head yet again. A lot of colonists would say, I own it, then come back to find out that someone else had already built a farm on their land, while the original owner would go storm back into town, complain to the colonial government, and can you guess who the colonial government would side with? They would side with the person who was using the land productively. There's that word again. But they weren't upholding the allowed 20-year window, and no time was really being applied to these disputes, which is kind of funny to consider. Like, one day you could claim land and then come back a few months later and someone just built a house on it and they're like, you should have been more productive, loser. So fast forward a bit to westward expansion in the US, and a lot more of this squatting was starting to occur. There are a few types of settlers in the American West. Some brought deeds to land they thought they owned, and others just went for it and made homes in the middle of nowhere. And can you see why this led to property disputes? Well, to manage all the chaos this was causing, the new state governments would carry on much of the use of English common law, again with the usage of adverse possession. Since a lot of settlers built homes and farms long before land was properly surveyed or deeds were distributed, courts used adverse possession laws in favor of the settlers that were being productive with the land. In some cases, the settler only had to reside on the land for as little as 5 years, and if the absentee owner did nothing to remove them during this time, and the land was being used productively, well, the squatter could gain the legal title and deed to this land. So with the early instances of squatting, it all sort of made sense, right? It was mostly frontier land and people needed to farm or whatever, but obviously this form of America didn't last forever. The 1900s saw America turn from a land of frontiers to largely urbanized living zones, and the logic behind adverse possession started to sour. There were some clear flaws with the system when placed in the context of the expanding urban sprawl of the new American city. Disputes shifted from undeveloped patches of land to empty lots, abandoned office buildings, and foreclosed houses. And all of the states had different answers for this solution. But one of the biggest differences that was universal was the introduction of what was called good faith occupancy. And this functioned as a check to make sure adverse possession wasn't being manipulated as a form of legal loophole towards free land. If someone broke into a boarded up building with the intention to just squat in it, that would not qualify as good faith occupancy. So then what is good faith occupancy? It can be best summed up by this example I made up. Say a tenant of a rented home finds out the landlord died and they can't find any official will, so the tenant decides to purchase the home after the bank seized it. Ends up the landlord did leave it to an estranged nephew who found out about it 5 years later. Now that nephew wants to sell the house. Well, if this was occurring specifically in California, the tenant could claim adverse possession laws because 1, they paid property taxes on it, and 2, they resided in the building for 5 years openly in good faith. So as you can see, it's extremely niche circumstances that the newer state laws would allow adverse possession to occur under when taking an entire building. And for the most part, a situation like that would never happen. But adverse possession is still used, but more commonly used now for property disputes, not on a scale that large, but on a much smaller scale. Say you find out your neighbor's fence is 1 foot into your property line and you take them to court to that because you're a petty jerk. If that fence has been up for 10 years and your neighbor has been paying property taxes on that 1 by 10 foot patch of grass that his fence took from your yard, well, the courts are going to side with him and say, adverse possession. But the key difference to all of this is the duration and whether or not taxes had been paid on the property, basically just to stop people from slowly consuming their neighbor's property and claiming adverse possession. As I mentioned before, courts did draw a line at trespassing and what was good faith squatting, and this all occurred in the late 70s to early 80s. The U.S. has had a few distinct squatting waves in our modern era, notably the Great Depression, saw shanty towns pop up. The 70s and 80s saw urban decay with mass squatting rates in cities like New York and San Francisco, and during the Great Recession of 2008, squatting popped up a lot in foreclosed houses. And we started seeing another uptick over the past half-decade for certain reasons. So that brings us to an important question. Why is it so hard to get the squatters out of the building? The laws around adverse possession seem pretty cut and dry, right? Well, I'm no lawyer, but the short answer is yes and no. There's a few reasons why squatters are hard to get out of buildings. For one thing, cops can't just immediately go in and remove them based off of one phone call. Though trespassing is a criminal offense, squatters are treated as a civil issue, a problem between the property owner and the squatter. To start, even if the landlord knows they are squatters, legally they cannot use force to remove them from the building. In fact, in some states, like Minnesota, for example, the landlord will still have to pay for utilities so the squatter can get heat in the winter. In fact, lots of states don't allow property owners to turn off water and electricity either because these violate laws against self-help evictions, or in other words, forcing a tenant to leave a building by force. Now, there are some states in recent years like Florida who have done away with all of this, but they are a very large minority. In most cases, the squatter has to be given an eviction notice and they will need to attend a court hearing to make sure it's not an unfair eviction. All of this takes a lot of money and, more importantly, a lot of time. The court hearing could come up quick if you're in the middle of nowhere, but if you're in a larger US city, it could take 2 or 8 months. The landlord is pretty much just shit out of luck if that's the case. And these aren't generally happening in nice places either, mind you. Squatters tend to post up in foreclosed, abandoned, or rundown properties that often have some ambiguity over ownership records. So if it's unclear who the property owner is, the court has to sort that out before any eviction process can even start. In some states, they made it even harder to get them out too. States like California or Colorado have very strange tenant right laws. If someone has been living on a property, legitimately or not, for more than 30 days, they can gain legal tenant rights, which changes all of this from civil court to housing court in order to evict them, making the whole thing take even longer. All of which is pretty crazy. But the thing that makes me laugh the most about all of this is the real reason why squatters are so hard to remove, when you really boil it down, is bureaucracy. It's really just local laws and courts taking a super long time in order to do anything, which allows the squatters to just stay put with full legal protection. And if you're in a major city like New York or Los Angeles, good luck, because that's going to take months. I've seen people doing funny shit to get them out, like having their friends bother them for weeks or living in the house nonstop messing with them, but those are some brave souls doing that, and the legality of that too is a bit blurry. Well, there you have it. That's why squatters have rights, and that's what their rights are. Like most things, we can blame the British. Did you learn anything today? Do you like this video? I sure hope you did, and if you're still here, consider liking and subscribing to your favorite little rat. Is there any topic you'd like me to cover? The suggestion box is open. Buy a sticker. Bye-bye.